Give me a signal. So good morning. Good morning, everybody. Hope everybody had a great long weekend. And welcome to our conversation this morning. It's an hour's conversation to be led by resource person Vince Wong. I will say a few words about Vince in a little while. And but before we go there, just to provide a little background, a little context to this particular webinar session. So the topic is immigration and refugee policy changes, and the resource person is going to lead us in this conversation by providing the broader context in which you do your work. So I guess there are two levels to this conversation. On the one hand, you will be bringing your experiences of doing service delivery to specific clients or community groups, as well as on the broader context, the kind of work that you do in terms of organizing, education, and policy advocacy. What you see on the board or on the screen, the work of agitating for change. There is obviously a connection between the individual service delivery that you do, responding to individual clients' needs or individual community needs. But we can only be effective at the level of the individual if we are also effective at the level of the bigger picture, which is the policy big picture context. Obviously, one affects the other. So the presentation and the discussion is going to look at what are these major policy changes in immigration and refugee, excuse me, that affects your work at the individual level. And secondly, how is it possible to make those policy changes that will therefore enable us to do our client servicing more effectively? So that is the broader context of the conversation this morning. Just excuse me for a second. Excuse this little cough. Okay, so that's the conversation for this morning, and in the broader context of our school for social justice, here is another image that, if you recall, we have used. On the vertical level, there is one question that we ask ourselves, what's going on around us? And then the response to that question is going to affect what we are going to do about it in terms of, let me just move this around, in terms of strategies and action plan. So these two are interacting with each other. And in the middle, of course, is you and your organization and agency and the Okasi family of, of agencies. So what's going on around us in order to asking this question in order to analyze issues, events, and structures, and as I said, specifically policies related to immigration and refugee services. Okay, that's the context of this particular session, situated in the broader social justice school, as well as in the broader social justice, or sorry, settlement work that you do. So let me pause here and see if there is any comment or question before I go to the introduction of our resource person. Do you have any particular question, comment? So there is one question somebody cannot hear. Yes, we have started. So let me type that up. Anybody else? Okay. No other question. So the next point I'd like to cover just very quickly, going back to the last session, which was around uh, charities and advocacy. Is there any, question right now that is important for you to address before we move on? Otherwise, if not, I will begin the introduction of our resource person. So it seems everybody can actually hear the conversation now. Okay, so we're ready. Just a slight technical, so it's okay. Our sound is okay.
Can hear now. Okay.
Okay, great. So again, welcome to this session, to the conversation that will be led by Vince Wong. Vince Wong, I'm happy to introduce, is the a staff lawyer of the Metro Toronto Chinese and Southeast Asian Legal Clinic. So his work actually involves education, advocacy, and organizing, with a particular focus on promoting equity and justice uh, in the wider community, of course, including the immigrant communities. And some of the issues that he addresses in his work relates to racism, specifically systemic racism, as can be seen in the gap between the rich and poor, and various levels of deprivation and exclusion and marginalization of racialized individuals and communities across Ontario. So it is the broader structures of injustice that he tries to focus on in order for us to be able to improve our services to our diverse communities and clients. So aside from being a staff lawyer at the legal clinic, he is also an alternate director of the Color of Poverty and Color of Change, which is a broad network that includes OCASI, addressing racism and poverty, among others. So I hope I'm sure you will have a great conversation with Vince. So welcome, Vince.
I'll just come in here. Yeah, okay, great. Okay, good morning, everybody. So my name is Vince Wong. Thank you very much for the introduction. I'm a staff lawyer at the Metro Toronto Chinese and Southeast Asian Legal Clinic. And just to introduce ourselves, we're a community-based legal clinic which provides free legal services to low-income members of the GTA's Chinese and Southeast Asian communities. And almost all the people that we serve face linguistic barriers and don't have English as their first language. So part of our mandate is to engage in law reform and test case litigation to challenge the laws which we feel disproportionately negatively impact on the communities that we serve. And as you can imagine, given our client's background, immigration law is one of the key aspects of our advocacy. And normally my boss, AB Go, does this presentation, but unfortunately she has a conflict today. But I'll try to do my best to talk about changes in immigration and citizenship law, and hopefully explain these changes to you in a clear and succinct way. So immigration and citizenship law is a really broad topic, and since the conservative government took power in 2006, there have been wholesale changes to the entire structure. And to talk about it would cover everything would take a little bit too much time. So my presentation this morning will be focused mainly in three areas. One are the recent changes to the family class sponsorship. Two is changes to citizenship, most recently BC 24, which some of you might have heard of, and I'll go into that. And three, I'll say a few words about express entry. And I'll try to frame everything that we do here in terms of kind of the bigger picture. As lawyers, we kind of tend to go into the nitty-gritty. It's necessary, but you often get lost in the in the forest, so to speak. So it's important to have the view at 10,000 feet and understand what's going on. So first I'm going to talk about family class sponsorship. And there's three, before we go into it, there's three kind of points that I want to make to frame this conversation. And then first is that I'm going to frame it in terms of a rights-based approach. So meaning that we're going to come from the point that we believe that family reunification, to be reunited with one's family, is a basic right, both in the context of the Immigration and Refugee Protection Act, which is the main law in Canada that governs immigration, as well as the Charters of Rights and Freedoms, and also internationally on international human rights instruments. And we'd also like to frame this in the historical context, understanding what the Canadian government's view towards immigration was in the past, and how a lot of these views, although they may seem different, a lot of them subtly creep into the rationale for the current immigration regime. And it's important to understand that there's continuation there. There's a legacy there that we haven't fully escaped from. And then third, I'd like to talk about some of the changes, the most recent changes, so the last few years that were introduced in family class sponsorship, and how we're trying to address those. So let's start with the first point, which is family reunification as a basic right. And I've copied for you here the part of the Immigration and Refugee Act, Protection Act, that lays out the objectives of the Act. And there are 10 explicit objectives, and obviously every single law, has a balancing of different objectives. But I want you to just note that it's explicitly stated in the ARPA, which is the Immigration and Refugee Protection Act, that one of the clear objectives is to see that families are reunited in Canada. Now, of course, you're balancing other objectives like, national security, like, economic benefit, and all these things. But family reunification is explicitly there, so it really lends credence to the fact that the framers of this law believed it to be a primary objective, believed it to be a right that shouldn't be taken away unless there was a very, very good reason to do so. And that's what we're here for. When we say family reunification is a basic right, we're not saying that it's an absolute right that can never be denied under any circumstances. But we are saying that the right to live with your family is so fundamental to the core of what the rights that should be provided to every person in the world, that if you take it away, you must be able to justify it. You must have that very strong justification. And that's where we're coming from here. So the second point I'd like to make is that family immigration in the last few years has become increasingly restricted. Now, before the 1990s, a lot of people don't remember the time, but uh, actually the majority of immigrants to Canada in the 70s and 80s, they came under family class, so greater than 50%. Now in 2014, and in about the decade before that, there's been an increasing shift away from family class immigration and more towards economic immigration. So if you see now in 2014, the latest stats we have is roughly 25%, 25.6% were family class immigrants, and the economic class, conversely, has really, really increased. So roughly 63.5% are now economic immigrants, where those numbers were roughly reversed prior to the 1990s. And I'd also like to just show you that it's not really the law. The law on its face didn't really change during that time. It's really the regulations, the priority of the government in accepting certain people. So if you take a look at the law, you might say, "Oh, nothing's really changed." I mean, like it's still essentially equal grounds, right? Like the chances of you uh, uh, getting immigration, getting PR here in Canada might be the same. And if you took a look at the definition of family class sponsors, it really hasn't changed. But if you take a look one level deeper, it will make it clear that these new regulatory changes introduced over the last several years are designed to make it harder for certain families to be reunited and for certain communities to flourish here in Canada. And the negative impact of the changes will be felt most harshly and have been felt most harshly by members of certain racialized communities, even though they may appear equal on their face. So that's why I kind of copied that quote from Anatole France there. The quote where in its majestic equality, the law forbids rich and poor alike to sleep under bridges, beg in the streets, and steal loaves of bread. And that's what I mean by it might seem equal on the face of it, but the application is very clearly impacting only certain communities. So for instance, and I'll get into this later on, there's a minimum necessary income requirement for sponsoring parents and grandparents. And the law may appear neutral on its face as it applies to everybody, but clearly the effect is disproportionately felt by racialized communities, women, and people with disabilities because these groups are more likely to have lower income, much more likely to live in poverty, and therefore be blocked, have that barrier from being reunited with their parents and grandparents who would be able to provide that familial support in other cases. Okay. Oh yeah, and if you have any questions, please just let me know, and we'll get them answered immediately. Okay. Otherwise, you can wait until the end of the presentation, and we'll do some Q&A then. Just a couple of statistics before we go into the minimum necessary income requirement. And I just want to show you that actually the statistics are coming. So I'll go into the minimum necessary requirement now. So what is this? So it's pretty much applied to the sponsorships of parents and grandparents and also adult dependent children. So any children that are over 19, but let's say they're going, they're financially dependent, maybe they're doing post-secondary education, or perhaps they have a mental disability. You need a minimum necessary income in order to sponsor them. So the minimum necessary income has recently in 2014 been increased by 30%. So prior to in the 1990s and prior, this didn't even exist. But they instituted it, and now they're, you could say, buffing it up. So to think about it, if you're a family of four, And this number does not include the grandparents or parents that you're sponsoring. You need a minimum of $54,684 family income to sponsor. This is actually pre-sponsoring a number. So if you add, let's say you're sponsoring two parents, that's actually a family of six. So it will shoot over 65, be in the range of $70,000 in terms of a minimum family income. And not only must you meet that income, but you must meet it continuously the 3 years prior to application, so you can't have a bad year. And only CRA documents are allowed to verify income. So if you make income, for example, and a lot of new immigrants do it this way because they're not unable to find other work. If you make it through a cash job or things like that, where you're not properly, verifying your income with the CRA, you have no opportunity to bring supporting documentation to verify that. So you can very clearly see that this blocks a significant amount, really middle, lower class and below are completely excluded from sponsoring their parents and grandparents. And I do want to go into the bigger picture. Okay, so why is the minimum necessary income so harsh on certain communities? And the answer to that can be just found in the stats. We found that studies have shown that over 75% of recent immigrants are racialized, and then that there's a double-digit persistent income cap between racialized persons and non-racialized persons. So if we're talking about recent immigrants or new immigrants or racialized communities that are trying to sponsor, they are already starting from a much lower base. So the median after-tax income for racialized persons was, in 1996, 23.2% lower than non-racialized, and in 2005, 16% lower. So you can see how this is sort of a reinforcing loop. So you have this labor market racialized income cap of 16%. That bleeds into the immigration sphere, right? Where you are denied, because of this income gap, you are more likely to be denied family reunification. But if you don't have family reunification, you don't have the familial support. You might have that child care so that the mother would be able to go back to work. The grandparents aren't there to be able to take care of children. And it reinforces this income gap and exacerbates it in a lot of ways. So you can see how the law, the immigration context, that works to structure a power imbalance here, and it reinforces it if it's not changed in certain ways. Little more statistics in terms of income gap. Between 2000 and 2005, racialized Canadians earned 81.4 cents for every dollar paid to non-racialized Canadians. And if you take a look compared to the men, the racialized men have made 77.9 cents per every dollar, while racialized women have cut that gap a little bit, so it's 88.2 cents for every dollar. But again, if you take systemic barriers and you add them together, you'll see that the effect is extremely pronounced. So for example, racialized women earned 55.6 cents for every dollar as compared to non-racialized men. And that really shows the example of systemic barriers reinforcing themselves. Now, poverty in Canada is also increasingly concentrated in particular groups. And there is an increasing racialization and feminization of poverty in Canada. So this is not something that you could say it will always happen, because we've seen in the past few decades the situation was a lot better. It's actually becoming worse now. So if in terms of incidence of poverty, racialized groups are 2 to 3 times more likely to be poor than other members of the community. So the poverty rate is 2 to 3 times higher. And in 2005 specifically, that meant that 19.8% of racialized families were in poverty as compared to 6.4% for non-racialized families. There's a massive gap there, and that bleeds into the immigration sphere as it does so many other areas of society. So in conclusion, I just want to say to wrap up the income inequity portion of it, is that given racialized and gender differentials in employment patterns and low income status, and given that these differentials are largely due to factors that are structural and beyond an individual's control, the minimum income requirement for sponsorship therefore has a differential impact on the ability of certain Canadian citizens and permanent residents to sponsor family members. And specifically, we're talking about members of racialized groups, women, and other historically disadvantaged groups. So the next slide, this slide, we're now going to talk about what you see in the media every day, okay? The public discourse on family class immigrants. Now, the government, they're clever, right? They are trying to control, and in a large way, they're succeeding in controlling the narrative and linking certain concepts, right? So what is the narrative that you always see when you're reading, any sort of major media outlet, not just the government's press releases, but really most major media outlets with respect to family class immigration, right? So you'll hear spousal sponsorship, most commonly linked to fraud, right? Abuse. You'll hear sponsorships of parents and grandparents, most commonly linked to burdens on society, burden on social welfare, burden on healthcare. And the third point I want to make is that you'll often hear family reunification. Well, first of all, to qualify it with Canada is, one of the is the most generous, immigration system in the world, and that family reunification is a privilege and not a right. And let's take a look at what the reality of that is. And I see we've got a hand here. How do we how do we get to that question?
Okay, we will wait for that question.
We have a hand.
Oh, okay.
Yeah.
So you click on the
Okay. Hi, Alexander. Do you have a question?
Yeah, I was just wondering, your thoughts on the minimum necessary income. I mean, when was it actually introduced, and do you think that it should be removed altogether, or is there a fair threshold? I appreciate your explanation about its disproportionate impact on racialized communities, but are you suggesting that we do not need any minimum necessary income at all, or is there a minimum threshold that you have in mind?
Right. Thank you. So to answer your question, the clinic is actually doing a constitutional challenge on the minimum necessary income requirement, arguing pretty much, based on what I just argued, that it violates certain charter rights. Now, so there's a balancing here, right? I mean, and we want to be fair, and we want to include different viewpoints and not definitely not ignore them, right? So there. See the things about all these three things that we're saying here, and particularly I'll go to the second one, which is the sponsorship of parent and grandparents, because this is where the minimum necessary income usually comes in, right? That it's a burden on society. It's like a lot of things, there's a certain amount of truth to it, and there's a certain amount of misinformation and myth to it, right? One part is that most people that come here through this parent-grandparent, they have to go through two things, right? They have to go through a medical check, and they have to go through a security check. Now, the medical check, in a lot of ways, already vets a ton of people out, right? If you have a pre-existing condition that Canada thinks that you're going to have a disproportionate impact on the healthcare system, you're already out for that purpose, right? And then there's the other thing, which is there's a sponsorship undertaking. So there's a 20-year sponsorship undertaking in which the sponsor has to basically pay for the social welfare, any social welfare of the sponsored person, in which this would be the grandparent or parent. The third thing is that before you're allowed any OAS, you have to essentially live in Canada for at least 10 years. So what we're saying is that there's different things already that prevent, that work together to kind of, let's say, prevent somebody from coming into Canada and availing themselves fully of all like the taxpayer paid social benefits. But if you add on top of that the minimum necessary income, they're not even able to come at all. And the Conservative government has also countered saying that there's a super visa, so you can come in and visit for, let's say, a period of 10 years. But even that has its own minimum necessary income, which is very high, and blocks out a large amount of people from even having their parents visit. So they're not even eligible for healthcare. They're not even so. It's about the balancing, right? It's a balancing of different rights, of different responsibilities. But if you're going to essentially block out everybody because of this and increase the minimum necessary income, increase the threshold, so essentially any lower middle class and under person just by blanket can never be reunited with their families here in Canada. That's an argument that I think cannot be sustained on the legal grounds. So it's a great question, and it's one of those things where a lot of debate needs to continue on. So I hope that is a satisfactory answer. So we'll move on. Amy, is there a way to minimize this? Is this it?
Yeah.
I could click it.
Yeah.
Okay. Okay, let's move on. Okay, so I'll just take a quick look over the historical context to frame this, and just quickly to show that Canada has sort of a long history of excluding particular types of immigrants for its purposes, right? They might be economic purpose, they might be political purposes, they might be military, nationalistic in certain cases. So specifically, it was the Chinese Canadians that were excluded because they were here as temporary foreign workers to build the railroad, but after their services were not needed for the railroad, they instituted a head tax, and then they outright instituted an exclusion. And then there's other laws that kind of discriminated or restricted those that were not considered desired, or another way that they put it, wouldn't assimilate properly, such as South Asians. And the 1914 case of the Komagata Maru is a case of that. I'm not going to go into the historical details, but I just want to show you that sort of idea, the temporary foreign workers, will allow immigrants here when it serves our purposes, but we don't want to give them full status. We don't want to let them enjoy the benefits that other Canadians enjoy, because we don't think that they are one of us, or we don't think that they're desired, or they don't accord to Canadian society. This is a long legacy. This is a long historical context. It's not just now that we're dealing with it, but it's surprising that now so many of those same thoughts, those same rationales come through, but they're veiled in different ways. And I just want people to understand that and keep that in mind when they're reading the news. So I'm going to quickly. So we've covered the minimum necessary income. Some other changes that were given by the Conservative government was in September 2010. They highly restricted spousal sponsorship, in that now you need to show both that it is a genuine marriage, which is fine, and the second one is that the marriage wasn't entered into primarily for immigration purposes. And this is pretty much where every single so-called, sham marriage is blocked, right? But they block a large number of genuine marriages, because who in their right mind would get married from different countries and not at least consider the immigration aspect of it, right? Who would not have the conversation of, well, where are we going to live? Are we going to live back in Pakistan, or are we going to live in Canada? If you're going to even have that conversation, you could argue that the marriage is going to be for immigration purposes. If you don't have that conversation and you're telling that to the judge, they're not going to believe you. So, I mean, and we've seen this all the time at the clinic, where people, the Minister's Council or the Immigration Refugee Board, they go on these fishing expeditions for reasons to refuse the spousal sponsorship, because they feel like there's that immigration status that was involved in it. And it's a very problematic definition that needs to be controlled somehow. It can't have that much discretion, because of the risk of the fishing expeditions, the abuse, and to use it for block everybody who they don't kind of agree with the relationship development. The second recent change is the conditional permanent resident status, that individuals applying for a sponsored spouse, that spouse has to live with them for a period of 2 years. And what the new rule is really saying is that if you're lucky enough to sneak through as a sponsored spouse based on a fake marriage, you have to be forced to stay in that relationship for 2 years. So there are exemptions in the law that provide for neglect or abuse, but the burden of proving that falls under the victim of abuse. And so, obviously there's a lot, people that are victim of abuse for a great many reasons are not in a good position to provide proper evidence of this. And so a lot of people, and again, we found this at the clinic as well, it exacerbates power imbalances, and it makes particularly sponsored women more vulnerable to control, more vulnerable to abuse. Do we have a question?
Yeah, we do.
Yeah. So, okay, thank you very much. So we have a question here from Zarit, and the question is, why is that sponsoring a child left behind by immigrants unregistered during their claim, under different circumstances, difficult to reunify? Almost impossible, as there is a modern system to verify their biological relationship. So I think, so this one we are going to address later on in a slide, if that's okay. So we'll get to that question when we talk about section 117. So we'll get to that soon. Thanks for the question. Okay. So then the final thing I want to get to is that there's a doubling of the sponsorship period. So now the previous undertaking for sponsors was 10 years, and now it's 20 years. So again, shifting that balance, making it less the state's job and more the individual's job of taking care of who they sponsor. 20-year period now to cover who you sponsor. Okay, so here's the issue that question was talking about, I believe, and that's another barrier to family reunification. And this section is one of the lesser known sections, but for immigration practitioners, it happens all the time. So it basically prohibits sponsorships of family members who were not declared at the time of the sponsor, that the sponsor submitted their own application. So what do I mean by that? So basically, if there is anybody that later on, like let's say you have a dependent child, but you came to Canada and you didn't mention them at the beginning, you are automatically barred from submitting them, even though that, like let's say a DNA test clearly shows that this is your dependent child. And a draconian application of this failure has resulted in untold hardship and separation. So let me quickly go into a case where this might happen. So in the case of China, there's a one-child policy. So a lot of immigrants don't declare their children because they have to basically have their children in secret. Otherwise, the family planning agencies might come after them with forced abortion, as well as forced sterilization and other penalties. But they become prohibited from sponsoring their children, their own flesh and blood, because they fail to declare. And so this provision, again, affects racialized communities disproportionately. And we really have no real good way of fighting against this other than applying for a humanitarian and compassionate application. So hopefully that answers the question. I know it's not very satisfactory, but that's what we're facing right now. So I'm not really going to go into this, but basically international human rights law also supports the view that this is a basic right. So if you take a look at articles in the Convention of the Rights of the Child, the CERD, the Convention on the Elimination of Discrimination in All Forms, it protects that right to family reunification. And again, you're forced to justify any violations of those. So the other thing that has changed greatly is the Canadian Citizenship Act. So they have start to take, I'm just going to go directly into it. They've increased the amount of residency, the amount of time that you have to be here in order to even apply to become a citizen. They've eliminated the time credit that you spend in Canada as a non-PR. For example, when you're a refugee, or for example, if you're a live-in caregiver, all that time is not credited. They've expanded the people that need to take the citizenship test. So before, it was from 18 to 54. Now, people that are from 14 to 17 and people that almost elderly people that are from 55 to 64 need to take that test as well. And of course, if you're a new immigrant and English isn't your language and you're starting from in your 50s to try to learn a new language, you're basically barring those people from being able to naturalize as Canadian citizens. They've also increased the fees for people to apply for citizenship. So in total, it's going to be $630 for adults, $200 for children, which is obviously very onerous for a lot of low-income Canadians. And there's a new power to strip dual citizens of their Canadian citizenship, and there's a limited access judicial oversight for that ability to strip. So basically what that means is that immigration officers make the final decision as to whether you will be stripped of your citizenship. And it's very difficult to get that judicial review in front of a judge. So the final thing that I'm going to talk about, and I'm really short on time. I just want to make a few points about express entry. Okay, so basically we know now it's very difficult to get through family class. Canada wants you to become here as an economic immigrant. Okay, fine. So what does that entail? So in 2015, in January 1st, express entry took place, which really covers all of the three major classes of federal economic immigration. So these are Canadian experience class, skilled workers, and skilled trades. And how it works is basically you make your application, you have a score, and you're ranked against everybody else who wants to come to Canada. The highest scores are invited to apply. So, so far, it makes sense, right? But the problem, even if you accept the conservatives' version, the narrative of how this will benefit Canada, even if you accept that, it's been a huge disappointment. So let me show you the numbers. So as of the mid-year, July 6, 2015, only 12,000 people were even invited to apply. So we're not even talking about, they haven't gotten their visas. They've just gotten the invitation, okay? Versus they had planned to bring in 84,000 people through these express entry categories. So they're at 12,000 invitations half the year through. So they're completely cutting the numbers even on talented people. And so how hard is it to get in? So if your employer goes through the highly bureaucratic process of getting a labor market impact assessment, there's no problem. But if you talk to any of these employers, it's an absolute nightmare to get one. Very expensive, very difficult, very arbitrary. Otherwise, the minimum score to get an invitation is 450 points. And just to give you an anecdote of how difficult it is to get 450 points, I have a friend of mine, he's a graduate from U of T Law. He got a job at a large firm, and his English is impeccable. He got almost perfect score. He's got higher education. He's got everything. He's 28, 29 years old. He ended up with a score of 442, and his work permit expired after 3 years. He got deported, right? So I mean, what? So I mean, I'm going to end the presentation on that note, but I can't emphasize or overemphasize how badly this government has really dropped the ball on immigration, and not just on the family class sponsorship, which we usually criticize them for, and they're used to that. But even in their own game, how poorly they've executed, how poorly they've gone toward. So we hope for better things in October 19th. So that, I guess I'll end with that. Yeah, so thanks for listening, and we'll open it up to Q&A, and I'll do my best to answer your questions. Is it possible to get a copy of this presentation? Yeah, absolutely. So Amy will email that out to all the participants. And I just want to thank you guys for having the patience on this Tuesday morning to sit in on this, and I hope you learned something from it. And I just want to say one thing about this School of Social Justice. I think it's a wonderful program, and it's really doing a great job to train and give the context, give the fundamentals for people that want to make a change, to want to better their communities. And I think it's just great, and I'm privileged to have a chance to participate. Is there any action taken against C-52 law? C-52? Yeah, C-51. I just want to make sure we're talking about the same law here. So are you talking about C-51, which is you could say is the spy bill? Because I think C-52 is the Canada Transportation Act amendment, of which I'm unfortunately not familiar with. C-51. Yeah, I mean, C-51, I think there are already, yeah. So if you're probably referring to the one where it gives, widespread powers to law enforcement as well as national security agencies. It's obviously very problematic, but I mean, the good news is that we have some brilliant people working on a constitutional challenge against it. It's led by Kent Roach at U of T, and they have analyzed the heck out of that thing. So I think it's going to be a very strong constitutional challenge and a very strong likelihood that that law is going to be overturned when it eventually gets to Supreme Court. Ah, okay. Oh, okay. So that's C-24. So C-24 is also being challenged by Constitution. So I mean, when you have a majority government like the Conservatives that are just pushing everything through, no matter nobody, they don't really care about it. The only real opposition is the Constitution, right? The court. If the court strikes it down, that's the only thing we can do to give them trouble. And that's why every single opposition group is essentially taking everything to the Supreme Court, saying that it's not constitutional. And they have very good arguments. So in terms, so I believe it's the British Columbia Civil Liberties Association, and the who else is challenging that? The Canadian Association for Refugee Lawyers, Lauren Waldman, that are going to challenge the constitutionality of that law. Let's go back to Alexander. From a legal standpoint, so the question is, from a legal standpoint, can the application of express entry be seen as an infringement of the human rights of immigrants based on non-discrimination? Ah, gotcha. So express entry clearly discriminates on education, language, experience. Racialized people will be affected. China no longer primary source country. So thank you very much. It's a great question. So here's the thing about immigration and discrimination, right? So the Ontario Human Rights, the Ontario Human Rights Code doesn't apply to immigration, for example, right? So in a lot of ways, if you're not in the country, the chartered protection doesn't apply to you, right? Even if you're in the country, yeah, technically it applies to you, but the charter and the court jurisprudence has always carved out an exception for immigration law to discriminate, because that's the whole point of immigration law. It's completely it's to let in certain people and exclude certain people. So by nature, it's discriminatory, right? And people have always that are sort of want more restriction on immigration have always put forth the thing that immigration law is the ultimate expression of sovereign power, our power as a nation, as a country, to control who comes in and who comes out. That's the major principal cardinal power of a country. So we should always protect that, and we should be able to do whatever the heck we want. So, if we don't want these people in the country, we should throw them in jail until, we can deport them and all these things. So there's the other side of it that says, wait a minute, even in immigration, even we know it's based on discrimination because, you're letting people in or you're kicking them out, you have to follow certain processes. You must still satisfy international human rights law. The way in which you deport people or detain people for deportation, it has to abide by the charter. And in a similar way, you might be able to discriminate based on merit, but you're not able to discriminate based on the fact that we don't like where you come from. We think you're a country full of terrorists. That is not allowed. The gray line, of course, is in between, right? Like it's hard to know. So if you're discriminating on all these things and you're having a disproportional effect on certain countries, that let's say are developing countries or whatever, can you say that you're discriminating on nationality, right? Is that blocked? These things are very unclear, and there's a constant battle in terms of which rights apply, how they apply to immigration policy. I mean, that's not much of of an answer, but I mean that's pretty much how I can tell you. Okay. So I'm sorry, I'm unable to take the final question as I understand that we're out of time. Jojo has to wrap up here, but if maybe it would be possible to get that question and I can answer it through email. But thank you again very much for giving me the opportunity to speak to you. Thank you.
Thank you, Vince. That was a great session, and I have taken lots of notes. I just have two quick comments. One is the overarching theme that Vince addressed, which is actually at the very heart of the School for Social Justice. We will not all be lawyers, and as Vince said, we don't want to lose the forest for the trees. So without going into all the legal technicalities, there's one concept that he repeatedly addressed in his session, the concept of systemic barriers. Sometimes the law seems to be neutral, but its impact on certain groups is actually unequal. So that's the very important concept in social justice, and he has given loads and loads of examples. So looking at the immigration law, he looked at the spousal relationship, the income requirements, the language test, the fees. They may seem to be neutral, but in fact they are discriminatory. So it excludes certain groups of people, racialized, applicants, and women, just to give two examples from this session. And that concept of systemic barriers actually applies to many of our sessions, okay? So we'll go back to that when we see each other in a week or so. The second concept is the historical context of the immigration policy. So those are just two quick comments, but I thought it was an excellent webinar discussion. So looking forward to the next meeting. You will do your project presentations on the second day of our face-to-face meeting on October 22nd, if I'm not mistaken. Uh, yeah.